appeal in the matter of the theme on the application of substation action take is after limited and speculative state for business, energy and industrial strategy and others.
Yes, good morning.
Good morning, my Lord.
Before we start, can we just tell you all this? We've had a good opportunity to read the papers, so we've read the skeletons, we've read judgment below, we've read some of the authorities, we've read quite a bit of the background kit. So you can take it that we're up to speed on the issues. We don't ourselves at the moment think that this is a day and a half, particularly given that the judge below dealt with a whole raft of things, including the issues in this appeal, obviously, but a whole load of other things, and that hearing was 2 days. So at the moment, we would encourage you to take today, but not more than that, because we think that that's more than sufficient, in fact, to deal with the issues that we've got.
My Lord, I'm grateful. If I might just say, the time estimate that was given on the grant of permission was 1.5 days, and we felt, as we had actually run out of time below, that it would be risky to resist that suggestion. But I think we have all discussed.
I completely understand why you don't resist that suggestion. Nobody would.
No.
If you've got an LJ saying, "Oh no, please have a day and a half," you're not likely to fight that. But that's why it's my duty to say, well, actually, we think you can probably do this in a day.
I'm very grateful, my Lord, and we will certainly endeavour to do that in accordance with the Court's wishes. But might I just start by briefly introducing the parties? I appear alongside my learned friend, Mr. Bishop. The first respondent, who is the Secretary of State, is represented by Mr. Westmoreland Smith and Mr. Welch. And the interested parties are represented by Mr. Hereward Philpott, King's Counsel, and Mr. Hugh Flanagan. So those are the parties. I think from my Lord's indication, I can take it as read that the Court has 3 bundles, a core bundle, a supplementary bundle, and an authorities bundle.
Yeah. We
have taken the liberty of handing up an A3 printout of 2 pages from the supplementary bundle.
Yes, that's very useful. I have looked at this map, but it is quite small, so that's very useful. And what's the other one?
It's 2 pages. One of them is the fluvial flood risk map.
Oh, yeah.
It's page 39 of the supplementary bundle, and the other one is the surface water flood risk map, which is page 40. And I'll come to that in due course.
Yeah.
As my Lords know, permission was granted on 2 grounds by Lord Justice Popperwell, and those relate to flood risk, specifically the sequential test, and to the cumulative impact of these developments together with future developments in the same location, Bristol. My Lords, I don't propose to take the background facts in any detail because the Court would have read them both in the skeletons and in the judgment below. Yeah. But just to emphasise, this is a case where there were 2 applications for development consent, 2 environmental statements, 1 examination process which combined the consideration of both applications of development consent, so they happened effectively together. As a result of the 2 applications, 2 examining authority reports and 2 decision letters. But for efficiency, since there is no difference at all for the issues with which we are concerned, we have included in the bundle only the decision documents relating to East Anglia North 1 and not to East Anglia 2.
Yeah.
So that is just efficiency, but there are effectively challenges to 2 development consent orders. So far as the onshore infrastructure is concerned, and that is the extent of my client's concern, there is no concern in respect of the offshore elements of these proposals. But so far as the onshore infrastructure is concerned, each development consent order consents, in summary, a cable from landfall to just outside the village of Friston, a scheme substation, so that is a substation for EA1N, and a substation for EA2 under the second development consent order, and a new national grid substation. To get
Is it one or two substations?
it's one national grid substation.
Yeah, and two.
There's two project substations.
Yeah.
So each development consent order authorises a project substation and a national grid substation. In fact, it is the same national grid substation authorised by both development consent orders.
Yeah.
So the effect is that the developer can build one or both. It effectively sits on consents for two consents for the same national grid substation. The distinction between the national grid substation and the project substations is an important point when we come on to the second ground before the court, ground 4 as it was pleaded. I'll develop that submission in due course. I set out in the skeleton some further background facts at paragraph 6 and following, just to emphasise that whilst the language of substation might on its face connote development that would be relatively insignificant, in fact the nature of these projects is that both the national grid substation and the project substations are of considerable size, and the figure that we put in the skeleton, which is derived from the environmental statement, is that the total area, the connection hub as we put it, extends to some 46 hectares of land on the edge of Friston village. The other contextual point is that these projects are part of a series of offshore wind farms in a particular area of the North Sea. Two of them were consented earlier, that's to say East Anglia 1 and East Anglia 3, and they connect through a different point of connection to an existing national grid substation at Bramford. The effect of these projects is to create a new point of connection to the national grid. So rather than connecting into an existing substation, they will themselves deliver a new national grid point of connection and connect in there. I've set out the relevant dates. It is a long process to get to the examination in the first place, and then a period of a 6-month examination followed by a decision period of a further 6 months. And that's paragraph 10 of the skeleton. My Lords, I appreciate the court will have familiarity with this area, but I set out in paragraph 12 of the skeleton the key provisions of the Planning Act 2008. I do so in very brief summary because I don't think any of them are an issue. But might I also direct the court to tab 10 of the authorities bundle, which is the first instance decision in the divisional court in the Spurrier litigation, which was round 1 of the Heathrow challenge to the airport's national policy statement. And the reason I refer to that is at page 200 of the authorities bundle, page 30, paragraph 34 and following. The divisional court, Lord Justice Hickenbottom and Miss Justice Holgate, provide a fairly detailed summary of the process for an application for development consent. That runs on into paragraph 37, where there is discussion of the effect of section 104 of the 2008 Act. And then turning forward, and just again to set the scene, to page 270 of the authorities bundle and paragraph 329 of this judgment. There is a brief discussion of how section 104 works in practice, noting that section 104.3 provides the Secretary of State must decide an application in accordance with any relevant national policy statement, and noting the analogy with section 38.6 of the Planning and Compulsory Purchase Act 2004, which will be more familiar to the court, which requires an application for development plan permission to be determined in accordance with the development plan. Just as that means in accordance with the development plan judged as a whole, as was suggested by the Secretary of State there, section 104.3 requires an application for a development consent order to be decided in accordance with any relevant MPS judged as a whole, and recognising, as has been said before in planning policy context, that statements of policy may pull in different directions, and therefore a breach of a single policy does not mean that there's a lack of accordance with the national policy statement as a whole. So I borrow effectively the commentary in Spurrier rather than going into any detail into the process of the 2008 Act. The relevant decision documents here are at tab 10 of the core bundle. I just note at this stage that the court only has extracts from the decision documents. The examining authority's report, and as I say, there were two of these, but the report for East Anglia 1 North is divided into 3 volumes, which are explained in the guide, the index at page 481 of the bundle. The first volume concerns the onshore matters and effectively the substance, the planning issues with which my case is concerned. Volume 2, which is also in the bundle, starting at page 627, we've included an extract simply for the overall conclusions on the case for development consent. So those were the examining.
So we've been spared the rest of volume 2 and all of volume 3.
Yes.
Well, we're very grateful.
Yes, we've done our best to edit. It's probably not a perfect job, but
it's still something of a doorstop in any event.
It is.
But,
it is.
We are grateful.
But my lords will have a sense that the issues here were many and varied. I think volume 1 itself in full runs to over 300 pages.
Yeah.
Volume 2 to a similar length. There is then the Secretary of State's decision letter,
Yeah.
which is extracted, and that is at page 666 and following of the bundle.
Yeah.
So I make those points just by way of navigation rather than by going into detail. My proposal, should it please the court, is to take each ground in turn
Yes.
and go to the relevant parts of the facts for each ground,
Yeah.
rather than comprehensively surveying the facts at the outset.
Yeah. And you don't need to take us to, I mean, we know where these are and we've read them, or at least the relevant parts of both of the examining authority report and the decision letter. So if there are references and extracts to the relevant bit, then that is sufficient. You don't need to take us to that to prove that that's the paragraph in the.
My lord, I'm very grateful. I'm very grateful. I'll give you references, and on occasion I'll have to turn them up. But
of course.
Take this.
And in terms of the structure of the letter, which is very long, is it page 765, section 27, where you get to the final conclusions on each of those, and where, for example, we learn that for flooding and drainage there was a high negative weighting. That's paragraph 27.4, third line. And for landscapes and visual amenity, he gave a medium negative weighting. So this is the accumulation of all the other bits that have gone on.
It is.
It is, right, okay. Thank you.
So, my lords, turning to the first ground, and the issue, as the court will understand, is whether the Secretary of State misinterpreted the sequential test in respect of flood risk. In the alternative, if he did not, or she did not, as she knows, whether she reached an irrational conclusion on the application of that test. And the starting point is, of course, the proper interpretation of policy. And again, I'll do this just by way of reference, but in Scarisbury, which is tab 6 of the authorities bundle, paragraph 19, Lord Justice Lindblom explains that the general principles relating to the interpretation of planning policy apply equally to the interpretation of a national policy statement. Self-evidently, that's the case, but essentially that the meaning of the policy is ultimately a question of law. However, caution needs to be applied in approaching that to ensure that a distinction is made between questions of meaning and questions of application. I don't think there's an issue in that between us. The sequential test then, the essential submission on this ground is that the sequential test is a site selection tool. on a proper interpretation, it is and must logically be prior to the consideration of whether particular impacts can be mitigated at the selected site. And in my submission, it reflects an unambiguous policy choice of seeking to keep development away from areas of flood risk. And as I'll show the court by reference to a couple of authorities, it is not the only place in the planning system where a sequential test is used. But in my submission, the effect of a sequential test is clear. It is to say, should we be here in the first place, rather than can we make these impacts acceptable? I'll turn then to the relevant policy. EN1 is the national policy statement, the overarching national policy statement for new energy infrastructure. It's in the supplementary bundle at the start of tab 2, page 240. As of the 22nd of November, this EN1 was superseded by a new EN1. But for the purposes of this challenge, it is this that was the adopted national policy statement. The court will note the overall structure of EN1 and the reference to general policy, the need for nationally significant energy infrastructure projects, general assessment principles, and then part 5 is concerned with generic impacts. In respect of flood risk, that section is section 5.7, which starts at page 275. And the first point of emphasis that I make here is at 5.7.3. The aim of planning policy on development and flood risks, or the aims, are to ensure that flood risk from all sources is taken into account at all stages in the planning process to avoid inappropriate development in areas at risk of flooding and to direct development away from areas at highest risk. Where new energy infrastructure is exceptionally necessary in such areas, policy aims to make it safe without increasing flood risk elsewhere and where possible by reducing flood risk overall. So in my submission, that is the clear and consistent message of flood risk policy. We'll see it reflected in the National Planning Policy Framework as well. It is, in my submission, absolutely clear that the starting point is direct development away from areas at highest risk.
Right, inappropriate development in areas of high risk.
Yes.
You wouldn't need the word inappropriate if it was all development, would you?
No, that's quite right, my lord. And there is some development which is applying the sequential test appropriate to put in areas of high flood risk. So the question of what is inappropriate is in essence dealt with through the application of the sequential test. But it's to direct inappropriate development away from areas at risk and exceptionally, to allow, if it is to be allowed, to ensure that the development is safe and flood risk is not increased elsewhere. There's then discussion of the assessment for the applicant to make. At 5.7.6, the court will see reference to further guidance in the practice guide to PPS 25. Now that guidance and PPS 25 fell away in 2012. This is a 2011 policy document. There's a reference to successor documents, and it's the MPPF, and then in due course the planning practice guidance that are the successor documents there. And again, I don't think that's in dispute. At page 277, 5.7.9, in determining an application for development consent, the IPC, and that's the Infrastructure Planning Commission, which existed in 2011 but didn't survive much long after that. So references to the IPC need to be read as the Secretary of State. Should be satisfied that where relevant, the application is supported by a flood risk assessment. And then the second bullet point, the sequential test has been applied as part of site selection, and that's the point I emphasise, as part of site selection. And then a sequential approach has been applied at the site level to minimise risk by directing the most vulnerable uses to areas of lowest flood risk. And I emphasise that because there are essentially two uses of the word sequential. One of them is the sequential test, capital S, capital T, as part of site selection. And the other one is a sequential approach when you come to design the development itself. So if you have a site which has some flood risk, then you ensure that the most vulnerable uses are directed away from that part of the site. That's the site specific. 5.7.12 and 5.7.13 in explaining the approach refer only to flood zones. Now the flood zones, which are flood zones 1, 2 and 3 in England, I think at the time it was A, B and C in Wales, those flood zones relate to fluvial flooding and risk of flooding from the sea. So it's those two types of flood risk that are caught by the flood zones. And the sequential test there is framed only by reference to those flood zones.
You say the sequential test there is phrased by reference to zones for flooding and sea, but river flooding and sea. But you're assuming that the sequential test, which says don't put it into zones 2 or 3, put it into zone 1, is the same sequential test for surface water flooding,
Yes.
and that there it's not a broader sequential approach as opposed to sequential test.
It is the same sequential test, but you have to apply it to flood risk from surface water, or from groundwater, or from reservoirs, or whatever the particular risk might be. But you must apply the same test. The difficulty is that the policy there is expressed only by reference to its application for those fluvial flood zones.
If that's correct, and it's the same test, then all you've got to do is to make sure that it's not in a zone 2 or 3. It's
Not,
got to be adapted in some way, hasn't it?
well, yes, the approach, the sequential approach, remains the same.
Yeah, the
but-
approach maybe, but not the test.
Well, the precise application can't be the same because flood zone 1 tells you nothing about the risk from surface water or groundwater or reservoirs or whatever else. The next point to emphasise is that the exception test at 5.7.14 applies after the application of the sequential test.
Sorry, hold on a moment. See, what was the last thing you said?
5.7.14, the exception test applies only after the application of the sequential test.
Yeah. What I'm wondering at is whether there's a broader thing. There is a sequential approach, which would make sense for surface water because, as you say, zones 1, 2 and 3 will tell you nothing about the risk. But then there is something in capital letters called the sequential test, which is the things you must apply when you're dealing with river and sea flooding.
Well, my lord,
You say no.
That may be a proper interpretation of this particular document,
Okay.
taken in isolation.
Right.
But the difficulty is that when we look at the National Planning Policy Framework, is that approach is not borne out.
Where in this document then is the definition of the sequential test in capital letters?
It's defined by reference to, well, first of all, in paragraph 5.7.13, but also defined by reference to the wider policies, the NPPF as now is.
Well, that again looks as if the sequential test, capital letters, is linked to zones for river and sea flooding.
Well, my lord, again, I can see that argument, although I'm not quite sure that's the way it's put by my learned friends in terms of rationalising the Secretary of State's decision. But in my submission, when we look at the NPPF, it's clear that the sequential test is supposed to refer to the application to all sources of flooding. And I don't think that's now in dispute.
Well, that's why there may be a difference between sequential approach and sequential test, but leave that to one side, yes?
My lord, I'll have that in mind as I make my submissions.
And can I just ask, 5.7.14, you said the exception applies there, if following the application of the sequential test, is that the same sequential test that had a capital S and a capital T?
Well, it doesn't have the capital S and T.
Well, I understand that,
I
but
think
is there any, I mean, since
no.
parts of this case border on the Chancery Division in about 1875, I just wondered whether there was any magic, supposed to be any magic in policy, where there's a capital S and a capital T, or here not a capital S and a capital T.
My lord, I don't say there's any difference there.
No. The capitals don't add or subtract.
I think that's right. The only distinction I was trying to make by referring to the capitals was if we go back to the second and third bullet point of 5.7.9.
Yeah.
There's a distinction between a test which is being applied to site selection and an approach at
Oh,
site.
I've got that. No, I've got that point. I just wondered if
No.
there was some extra force or magic in the capitals.
No.
It doesn't look as if there is.
No.
It looks slightly random as to whether the drafter has remembered to put them in capitals or put them in capitals and then not change them.
I certainly don't say that anything turns on that once we get to the document.
But the point is there's a difference between the test and a wider approach, because the test, whether it's put in capital letters or lowercase letters, may be linked to flood risk, because 5.7.14 appears to apply the exception test when it's necessary to put them into flood zone 3 or C in Wales. Then the exception test can be applied. But presumably, the exception test on your case must be applicable even if you're dealing with surface water.
Yes.
But it doesn't seem to be within 5.7.14.
In terms, it only refers to the fluvial flood zone. I accept that. In 5.7.14. At 5.7.15, it emphasises the exception test is only appropriate for use where the sequential test alone cannot deliver an acceptable site, taking into account the need for energy infrastructure to remain operational during floods. So, again, I say logically prior question of whether you can have a sequentially preferable site. And then under the heading mitigation on page 279,
Yeah.
we see reference to various means by which flood risk may be managed. And I just draw attention again to the reference to a sequential approach, 5.7.23. The sequential approach should be applied to the layout and design of the project. All vulnerable uses located on parts of the site at lower probability of residual risk of flooding.
So where was that?
That's at the top of page 280, paragraph 5.7.23. And I emphasise that's under the heading mitigation. My lords, if I can then go to the National Planning Policy Framework. We have at tab, in the same tab, but at page 293, the MPPF as it stood at the time of the application, and it was amended after the application had been made. And I just show the court briefly, paragraph 100 on page 294, which is effectively the same phrase as we have at the outset of section 5.7 of the MPS. Inappropriate development in areas of flood risk of flooding should be avoided by directing development away from areas at highest risk, but where development is necessary, making it safe without increasing flood risk elsewhere. And then effectively you do this by, first bullet point, applying the sequential test, and then if necessary applying the exception test in the second bullet point. And then 101, the aim of the sequential test, steer new development away with areas with lowest steer new development to areas with the lowest probability of flooding, should not be allocated or permitted if there are reasonably available sites appropriate for proposed development in areas of lower probability of flooding. And there, my lords, no reference to fluvial flood risk exclusively and merely to risk of flooding. And then at 103, this is dealing with...
So just looking at 101 again, I don't want to be unduly semantic, but you've got the aim of the sequential test And then the last sentence is the sequential approach should be used in areas known to be at risk. That does seem to suggest that there's something broader for other types of risk. If you follow me.
So,
The first sentence says the aim of the sequential test, and that's all linked again with what it says there, but then you go on to the last sentence, and for some reason it changes to a sequential approach.
Yes, my lord. I see the point, and what's clear from this is that when the examining authority came to look at matter, they thought that the sequential test applied under this policy only in respect of fluvial flood risk.
Yeah.
That's absolutely clear.
Yeah.
They also thought that that policy changed in the 2021 change to the MPPF. So I'll show the court that, which might help make sense of answer that question. And paragraph 103 again.
But
just
on your case, there was always a sequential approach, but not necessarily a test, where there was any risk of flooding, which could include surface water.
Yes.
And that's what the Secretary of State says. So it's a clarification, not a change.
Yes, that's what the Secretary of State says precisely. And then just paragraph 103 at the top of 295, the same thrust, but dealing with decision making on planning applications following the sequential test, and if required, the exception test. And then there's the reference to within the site. The most vulnerable developments located at areas of lowest flood risk. So that is MPPF as was, and then we have the extract from the adopted version, which was 2021, and the change in language here is effectively at 162. Sorry, it's page. I'm sorry, it's page 309 of the bundle. Page 309 of the bundle. 161 explains the overall approach, a sequential risk-based approach to the location of development, taking into account all sources of flooding. So that's in respect to the location.
So as to avoid where possible.
Yes. And then they should do this and manage any residual risk by applying the sequential test, then if necessary the exception test. And then para 162, the aim of the sequential test is to steer new development to areas with the lowest risk of flooding from any source. Development should not be allocated or permitted if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding. The strategic flood risk assessment will provide the basis for applying that test. And then, again, my lord, it's the phrase, the sequential approach should be used in areas known to be at risk now or in the future from any form of flooding. But what's clear is that there, at least there, the reference to the sequential test and the sequential approach is not suggesting two different approaches or tests. Or any source of flooding, apply a sequential test to steer new development to the areas with lowest risk. And helpfully, the planning practice guidance, which we see at page 313 and 314, refers at page 314 under the heading, the aim of the sequential test. What is the aim of the sequential test? First of all, and this is where the words become elided, the sequential test ensures that a sequential approach is followed. Just under the heading, what is the aim of sequential test, under page 314?
314, sorry, yeah.
Sorry. The sequential test ensures that a sequential approach is followed to steer new development to areas with the lowest probability of flooding. So there are no distinction between any types of flooding. And then it says the flood zones, as refined in the strategic flood risk assessment for the area, provide the basis for applying the test. And then there's an explanation again of the three fluvial flood zones. But then at the top of page 315...
So can you just leave us? You've got to start. you read it from the middle. You've got to start at the top. What is the sequential risk-based approach? The general
Yes.
approach is designed to ensure that areas at little or no risk of flooding from any source are developed in preference to areas at higher risk. And then another sentence, the aim should be to keep development out of medium and high flood risk areas, zones 2 and 3, and other areas affected by other sources of flooding where possible.
Yes.
So this appears to be a general approach which includes what I call the sequential test, but also dealing with other areas and keeping it out of other areas where there's other sources of flooding where possible. So that's the start. That's what the test means.
Yes.
And then, having said what it means, the bit you've just read is the aim, is it?
Yes, that's the aim. And then it describes the flood zones as the basis for applying the test. But then if we turn over the page to 315, within each flood zone, surface water and other sources of flooding also need to be taken into account in applying the sequential approach, and then I emphasise, to the location of the development. So this is not a different question here. Where should this development be located is the question.
But is that talking about within each flood zone?
Well, my lord, no. The way I read it, and I think the way common sense would read it, and it's given all the references to sequential tests and sequential approaches, it is not entirely straightforward. But I read it as it is, you start with the flood zones because they're going to give you the immediate objective assessment of areas of fluvial flood risk. But then, having looked at them, you need to go on and consider whether there are other sources of flooding that might need to be taken into account. So you may find yourself in flood zone 1, but before you can go on and say that is a site which is appropriate under the sequential test, you've got to say, however, is it affected by another source of flooding?
And here we're in flood zone 1, so within flood zone 1 for surface water, we've got to decide where to put it within flood zone 1. Is that it?
My lord, here we're in flood zone 1 for fluvial flood risk, but an area identified as being between medium and high risk for surface water flooding, at least in part of the site.
Yeah. So within each flood zone, and here within flood zone 1, you're either going to be 1, 2 or 3, so you're going to be within a flood zone, and here we're flood zone 1, and you say you've got to look at other sources of flooding in applying the sequential approach to the location of development.
And the sequential approach there is elided with the sequential test, because the sequential test ensures a sequential approach is followed. And then that analysis is correct, and my submission is confirmed at page 316 under the heading, how should the sequential test be applied to planning applications? And the third paragraph, nor should it normally be necessary to apply the sequential test to development proposals in flood zone 1, unless the strategic flood risk assessment for the area or other more recent information indicates that there may be flooding issues now or in the future, which again, in my submission, captures the other sources. And then over the page at 317, when applying the sequential test to pragmatic, this is at the top of the page, a pragmatic approach on the availability of alternatives should be taken, and it gives some examples of that. And then in the second paragraph of that page, any development proposal should take into account the likelihood of flooding from other sources as well as from rivers and sea. The sequential approach to locating developments in areas of lower flood risk should be applied to all sources of flooding, including development in an area which has critical drainage problems as notified to the local planning authority by the Environment Agency, and where the proposed location of development would increase flood risk elsewhere. So, in my submission, quite clear there in the PPG that we should be looking at all sources of flooding in applying the approach, or the sequential approach, or the sequential test to locating development. My lords, I say, as a result of that, it is quite clear that the sequential test is concerned with the site selection stage and not with the detailed design within the site. The requirement is to show there aren't any reasonably available sites with a lower flood risk which could accommodate the development. This test is also logically prior to the site level sequential approach, moving your development around within the site, and also logically prior to making the development safe and not increasing flood risk elsewhere. That is confirmed by the express purpose repeated in all the relevant policies: steer development to areas of lowest flood risk. And in terms of the test, it is a point in the NPS on which the decision maker should be satisfied that there has been a sequential approach to site selection, having regard to all sources of flood risk, and in the NPPF, development should not be permitted unless the sequential test has been followed. And it follows that non-compliance with that element is a breach of that part of the national policy statement. There are, in my submission, two different points about the application of this test, which my learned friends allied in their submission. First of all, it is not in doubt, as I see it, that the sequential test applies to all sources of flooding. And that is notwithstanding the references in the national policy statement to fluvial flood zones. But that point's now accepted by the Secretary of State and the interested parties. There's then a question as to how you go about applying the sequential test. And neither the national policy statement nor the NPPF are prescriptive on that matter. The planning practice guidance does provide some guidance, but ultimately how you apply the sequential test is going to involve questions of planning judgments in any particular case. What are the reasonable alternatives? Are the sites with lower flood risk constrained by other means? For example, are they objectionable on greenbelt grounds or development in an area of outstanding natural beauty? But that question, how you go about applying it on the facts of the case, does not mean that you can come to a conclusion that you just don't apply it at all. And secondly, it's absolutely clear from the structure of all of those policy documents that the site-specific consideration, which is, can I make this development safe? And can I avoid flood risk elsewhere? That consideration only arises once you have carried out the location question. Should it be here at all? And you can't answer the location question by answering the site-specific. My Lord's vindicated.
And that's your submission on the first point.
That's my submission.
Yeah.
In terms of the evidence here, the key point, I know my Lords have the documents understood, and I just want to emphasise the key point, which is that, and it's lost in the judgment below, but there is a risk of surface water flooding to this site, and specifically to parts of the National Grid substation, and to parts of the wider site at Friston, including the access road.
Well, just break that down. Most of it is in an area of low risk, or probably in an area of low risk. There's a bit of the northwest boundary, and there's another bit where they say it's not. Where there's a medium, I think, and a high risk, depending on which bit you are. Might be useful to show us precisely the paragraph or paragraphs that confirm that, although I think I've got them.
So if I go straight in, so the first document that we have is the preliminary environmental information. So this is the consultation environmental statement. And that starts at the start of tab 1 of the supplementary bundle. And if we go to page 23 of the bundle. It's the numbering in the middle of the pages. Apologies for the duplicative numbering. It's numbering the middle of the pages.
So just exactly what this is part of the environmental statement, is it?
This is
part of the flood risk assessment.
This is the preliminary environmental information. So this is the consultation information. And this is where the flood risk is identified.
So is this the flood risk assessment that they've got to carry out?
No, I can go straight to the flood risk assessment if the court would prefer that.
No, you've taken us to page 23, have you?
I've taken you to page 23. That's concerned with the flood risk to the onshore substation and national grid infrastructure, which is what we're concerned with.
I'm looking at page 3 first. I want to know, before I get to page 23, which is paragraph 91, I'd like to know what 91 to 90 are. And so I went to the first page, and
Yes.
it's just got flood risk assessment on the first page, page 3.
Yes.
So I just assumed, and then you go to page 50, to page 9, and that's flood risk assessment. So it's not the flood risk assessment, that's a special thing under the thing. This is something called a flood risk assessment, but it's an assessment of flood risk, not a flood risk assessment.
Well, my lord, I'm sorry, I should be clearer. So the preliminary environmental information is the document that is consulted on before an application is made for development consent. So the statutory process under the 2008 Act requires the applicant to consult before they apply. And this is the flood risk assessment part of that preliminary environmental information. There is then, I hope not too confusingly, but there is then a flood risk assessment,
Which is the thing properly so
that
called,
came
actually,
before the examining authority.
Right, so this is the earlier one then.
This is the earlier document, and I'll just give the
Sorry to interrupt you. This is to show that parts of the site there's a risk of surface water flooding.
Yes.
Isn't there simply one document we can look at for that? Do we need to do the archaeology?
My lord, perhaps not.
I mean, maybe we do. I don't know, but I would have thought that was capable of being summarised in a paragraph or by reference to one plan. I don't know.
I thought it was page 170, but you're telling me that's wrong. Paragraph 125.
My lord,
4125.
Yes, I'm happy to go there. I just can I just give the couple of references I wanted,
sure.
Which were that section starting at paragraph 97 of that document, page 23 of the core bundle, concerns the onshore substation.
Yeah.
There's reference to a sequential approach, but that is only applied in respect of flooding from rivers. See paragraph 104, CB 24. And then there is the identification of the surface water flood risk, para 113 through to 115, page 26.
You say core bundle, but we're in the supplemental bundle, aren't you?
I'm sorry.
Yeah. Sorry, I'll just go to the other bundle. Do you want to give us the
No, that's
references
my
again?
fault,
Because I just picked up the other bundle.
23, 24, pages 23, 24 and 26.
Thank you.
Yeah.
24 and 26 of the supplementary bundle.
Supplemental bundle.
Thank you.
Yeah.
Very helpful. Yeah.
So
Sorry about that.
the next point, and can I just take it in this order, getting to my lord's reference, which I'll get to very quickly, but just to emphasise, the next document is the two extracted plans, which we've produced in A3 for the court, and that's the supporting figures, page 39 and 40 of the bundle, and this is just the simple point of reference. If one compares 39, no fluvial flood risk on the site, which is the black and blue boundaries, but then if you flip over to page 40, the areas of 1 in 30 and 1 in 100 surface water flood extent encroach on the sites. There's then, just to pick up the next document, chapter 4. This is then in the substantive environmental statement. Chapter 4 is included the site selection and assessment of alternatives. And the only point that I emphasise from here, and the court will see it at page 117 for the project substation, and at page 124 for the national grid substation, is that the assessment of locations for these pieces of infrastructure did not consider surface water flood risk.
Did not consider?
Surface water flood risk. They only considered fluvial flood risk. So in both cases, flooding is identified as a potential constraint, but not applicable to these sites because we're in flood zone 1.
Right.
And then, my Lord's already got there, 164 is the flood risk assessment submitted with the application.
Oh,
And page 170 124 through to 128. And my Lord's already have the point about the description of the flood risk there, which is variable across the site, but there are areas at high and medium flood risk. One point that I emphasise here is at 128, there's reference to the surface water flood risk extending downstream to Friston.
so it's the National Grid substation at the compound ceiling end, is it, whatever that is?
Yes,
Cable ceiling end, compound and permanent access road.
yes. Yeah, so the cable ceiling end compounds are where a cable has to go from being an overhead cable to an underground cable, or vice versa, and it requires an area to earth the cables and then put them into the ground. And it's a distinct piece of infrastructure, but it's within the National Grid substation.
Right. It's not easy to put 125 into words that an ordinary person understands.
No.
And I don't know how much of it is or isn't. Your clients will know it immediately, but I wouldn't know. The north and western boundary around the substation included the cable ceiling end. That's when the cable goes into the ground. So that sounds as if it's the boundary rather than the substation itself. And part of the footprint of the National Grid substation includes areas at high risk of surface water flooding and a medium risk of surface water flooding. It's not easy to tell how much of the... I know you will say it doesn't matter, but it's not easy to the reader to know how much of it is.
And my Lord, that's a consequence of the fact that we don't have a detailed design here.
Yeah,
so
I understand
effectively, whilst it's more than the blocks that you see on those plans, effectively it is a consent to build this infrastructure within an area subject to certain parameters, and all of that's to be settled later.
Yeah.
So all that we know is that the areas that are identified for the substation and identified for the cable ceiling end compounds, which the distinction between the two is in my submission not material for the court's purposes. It's part of the kit.
Don't we see all this on 40?
Yes.
There's the rectangle and there's some blue in the north. And I mean, I like plans. They usually save 1,000 words or more. It's my TCC background, but it's all shown. There's the rectangle. There's the bit of blue.
Yes.
Yeah.
We know that the kit, however so described, is going to be put broadly within that box.
Yeah.
And we know that there's an area of high and an area of medium surface water flood risk in that box.
Right.
But to my Lord Justice Lewis's question, we don't have before the court, and it wasn't before the examination, an area that would be affected of each of the component parts. I think essentially because they weren't determined.
If I look at the bigger plan that you gave us this morning, and I've got the red rectangular boxes, there's a bit in the middle under the words the old school that's got looks like the 1 in 100, and then there's a bit the left hand box above Friston House, I think it is, that's also got darker blue. So those are what we're talking about, is it?
Yes, is my Lord on page 40?
Yeah, 101, with the bigger...
Yes, thank you. Yes, absolutely. There's effectively a line which goes through the black box, and you see within that patches of the 1 in 30 and patches of the 1 in 100.
So it's between Friston House and Woodside Farm is the area of 1 in 30, and the lighter bits are the 1 in 100.
Yes, but the area of 1 in 30 runs right the way up.
From Woodside Farm all
From
the way
Woodside
up,
Farm to the
and
black
then it
box.
turns right to the black box.
Yes, and the you get a reference to that in the flood risk assessment, because it identifies that the access road, which will come from Sapsmundham Road round Friston House towards that black box, crosses an area of 1 in 30 highest surface water flood risk.
So are we just concerned with the dark blue in the little square rectangular that's marked black, or are we also concerned with the bit that's within the development area?
Yes, is the wider development area as well. So the flood risk assessment identifies some different areas of risk, and we see that at 125. There's focus on the National Grid substation site at 125, and then 127 explains the risk to the access road. And we see in the last sentence of 127, parts of the access roads are likely to cross areas at both high risk of surface water flooding and medium risk of surface water flooding.
Yep, okay.
And this black box is just indicative,
Yes.
because I mean, if you looking at the scale, the black box is about 400 metres by 100 metres. Presumably
Yes.
that's not the size of a substation.
It's not. The compound is of a substantial size, but then effectively it's an open space with a number of different housed components and open air components. The red line indicates the application boundary, and the court will immediately see that covers a far greater area, and in some parts of the application boundary there's not much happening. So, for example, the access road comes through at one point, but the precise location and form of the substations, both project and National Grid, is left for later determination.
And they say that those bits are going to be dealt with at 132, effectively by management of the surface water flood risk. But you say that's not good enough. They must first consider, should it be there at all?
Precisely, my lord. So that's exactly the point. My next point, that the sequential test that Zen applied, which we see at 173, doesn't consider the surface water flood risk, as my lord observes. Effectively, that's dealt with by way of mitigation. The slight oddity, and I draw this to the court's attention because it makes some sense of the later reasoning of the Secretary of State. The slight oddity is that when the applicant produced, during the course of the examination, a further document, which is page 205 of the same bundle, the flood risk and drainage clarification note, it did not acknowledge the surface water flood risk to the sites. So it didn't identify in the same terms that risk. And it may be that's because it was at that point dealing with the detail, i.e. what are the return periods and the flows, etc. But it didn't in terms spell out that the area was an area of surface water flood risk.
What does paragraph 26 say? It is noted that the only identified possible source of flooding would be from surface water.
Yes, yeah. So it didn't identify. Sorry, it didn't identify it in the same terms. That was just the point I was making.
Oh.
It didn't identify the areas of flood risk.
Well, I hesitate to rise, but just so that it's absolutely clear while the learner friend's on his feet, what's just been said is highly controversial. We say it's dealing with exactly the same issue, but it's looking at it in more detail on the back of the Friston study. So this is going into more detail on the surface water risk than was evident from the EA map which you've been provided. So just so my learned friend understands, that's the way we would do it.
and paragraph 23 actually, part of it lies within an area that could be affected by surface water conveyance routes. So it does seem to look at surface water.
Well, my lord, yes. Sorry, the only point I was making, I didn't mean to provoke my learned friend, but the only point I was making was that it doesn't describe it in the same terms. The flood risk assessment identifies, the flood risk assessment identifies a high risk of surface water flooding for part of the site, a medium risk for another part of the site, and low risk for the other. That language is not replicated in this document.
I can't help thinking that, in the words of Lord Justice Lewison, we're beginning to island hop. This is an appeal on that the judge applied the wrong principles.
Yes, my lord.
It's not an appeal of fact.
Well, my lord, there is one point of fact.
There's the you're quite right. There's the Friston point, but I thought we were on the first point. Are we not? Or is this part of?
I was dealing with the two together.
Oh, okay.
But
all right.
my lord, I take the point.
There is that point. So that's a permissible bit of island hopping.
Yes. My lord, I'm not going to. I don't want to wade in too deep into these documents. I fully appreciate the role of this court, and indeed the role of the court below is not to.
Yeah, but you are quite right that I have very much in mind that I've called it Ground 1B.
I'm grateful, my lord. I think I can leave the documents. I think the court has the first of my factual points here. Can I then turn to the examining authority's report? So that's core bundle tab 10, and the relevant part is at page 521. Findings and conclusions in relation to flooding and drainage. And a summary of national policy, which I don't criticise, at 6.2.1 and 0.2, and over the page. The issue arises at 6.2.4, where the examining authority refer to EN1 and the MPPF and the planning practice guidance, and note the revised MPPF, which I've shown the court. It then says in the last sentence, section 14 of the revised MPPF contains the UK planning policies for managing flood risk and seeks to ensure that flood risk is considered at all stages in the planning and development process to avoid inappropriate development in areas at risk of flooding and to direct development away from areas at risk of flooding. No dispute there. And then it explains the sequential test, directs development away from areas at highest risk of flooding by the application of the sequential test, and then the exception test. But then the last sentence of 6.2.5, the revised framework comprises a significant change in approach regarding the sequential test, which should now take account of all sources of flooding. So that's the approach of the examining authority, and they draw their conclusions on that basis. And if we go to page 527, 6.4.8, there's a consideration of the adequacy of the assessment, and the point put by my clients is that there's a fundamental failure because there was no consideration of what's described there as pluvial, which is surface water flood risk, pluvial flood risk. And the submission, which in essence is the submission I maintain today, that if you apply those policies correctly, the proposed development should be regarded as having failed to apply the sequential test, and thus contrary to a fundamental part of the MPS. And there are other sites which are not at flood risk, which would be suitable, and it follows there's a failure to apply the sequential test. The inevitable conclusion is that Friston should not be preferred, and development consent should be refused. So that's the case then, and it's the case effectively before this court. At 6.5, section 6.5, there's the examining authority's response on these points. And I emphasise in particular 6.5.2 and 0.3. I won't read them out because the court's already read them, but emphasising that the examining authority's understanding was that the sequential test had been satisfied in the applicant's assessment because the sites were in flood zone 1. And then at point 4, there is a significant change, they say, to national policy. And then that is explained further at 6.5.5. Second sentence, the inclusion of all sources of flooding means that the need for a sequential test may be triggered if a site is located in an area at high risk of surface water or groundwater flooding. And then this is important, the XA considered that on the basis of the evidence before it, Friston should be considered an area at high risk of surface water flooding. And the point I emphasise there is that when those conclusions are read with all the evidence, that must mean the area of the development site.
So say that again.
It must mean the area of the development
What is it?
site.
It must mean
That phrase, Friston.
Oh,
Friston
Friston.
should be the Friston site. That, in my submission, is the only fair reading of what's said there. And then
it means the whole of the red area, the boxed area, the whole of the development.
no, not the whole of the site, but part of it, such that it is an area at high risk of surface water flooding.
Right. So Friston means that part of the site which is in a medium or high risk of surface water flooding.
Yes. Well, it's the site. The site is at high risk because part of it's at high
Yeah,
risk.
that's what it means. So Friston
but
equals
which
the development site.
The whole of the red
Yeah.
box.
the substation development sites.
Well, that's my question. Because it's quite clear that there are large parts of the red box, including areas much closer to Friston, that aren't the subject of any surface water flooding risk.
Yes, but the fact that there is high risk within the site is sufficient to reach the conclusion that the site should be regarded for the purposes of the sequential test at being high risk, as being at high risk of flooding.
That may be a bit of a stretch, given the size of the site and given the very small parts of the site that are the subject of surface water flooding.
Well, my lord, that in my submission is.
I mean, isn't that more concerned with the precise locations within the site?
Well, my lord, yes.
I mean, you could put these boxes, for example, just to the north of Church Farm, and they wouldn't be in a surface water flooding risk at all.
My lord, the question being asked here is by reference to the sequential test.
Well, I understand that.
There are a series of sites which we see in the alternatives site assessment. There's a series of different sites. This is Friston for those purposes.
So this is Friston, and by Friston you take that to mean the entirety of the red box, from the coast to Moor Farm.
No, my lord, if we could just go very briefly back into the supplementary bundle at page.
Just tell me what when we were looking at paragraph 6.5.5.
Yes.
Friston there means what?
The site selected for the substations.
Well, why does it mean that?
Because the context here is the application of the sequential test, i.e. where should this development be located? The sites which are under consideration are at page 147 of the bundle, supplementary bundle. And the areas identified as 7 and 7A.
Hang on.
And what is this document in the bundle?
This is the appendix to the alternatives chapter, chapter 4 of the environmental statement, which I
Right.
brought briefly. So these are the alternatives that are being considered for substations.
At 147,
147,
onshore substations options overview.
and you have the various boxes. 7A and 7 are Friston.
Really, does it matter? Because we know that one bit of the site or bits of the site the northwest boundary, the cable ends are within a medium in one case and high risk surface water in another. It doesn't matter what they say, 6.55, that is the position.
Precisely. It doesn't much matter, but the conclusion there obviously is the right conclusion to draw, because if you're looking at all the sites where you could put a substation, the Friston site, which is where we've ended up, should be considered an area at high risk of surface water flooding.
It doesn't matter what it means, because if you're right that the sequential test applies in the way that you say it applies to surface water areas, once there is any part of any of the development site that is at medium or high risk, they must decide whether another site would be appropriate.
Yes.
So in a sense, 6.55, very interesting, but
Well,
not as critical as you might think.
No, it sets up the problem then for the examining authority. The problem that's posed then to the Secretary of State is that at 6.5.6, the PPG hasn't been updated. At 6.5.7, the change occurred after the close of the examination. There hasn't been a chance to comment on it. And then, given the significant change in approach and given the clear evidence that surface water is a flood risk to the village of Friston, the XA considers that in the interests of fairness, the Secretary of State may wish to consult the parties on the potential implications of the change. So that's how the XA leave it on flood risk.
And in terms of what they say there's been an alteration which they regard as a significant change of policy. That happened afterwards, they think. You say it happened before.
Yes.
But on any analysis, the documents that describe how the sequential test is to be applied has been adapted to take account of flood risk outside river and sea. And they say the Secretary of State may want to consult on that.
Yes. Effectively, they're not drawing a conclusion on the question because they know that the applicant's flood risk assessment only applied the sequential test in respect of fluvial flood risk. They think the policy then changed after they heard that evidence.
And what was their overall, did they give a weighting to the flood risk?
Yes, and then at 540, the conclusions. Again, first bullet point, significant change in policy, that the sequential test should now take account of all sources of flooding. Second point, cannot reach a conclusion on whether the proposed development satisfactorily passes the sequential or exception test because of that change in policy. And for those reasons, if the Secretary of State wants to make the order, there should be further consultation on the implications of that. So effectively, they leave it open. They don't make a recommendation that the sequential test has been passed because of the change in policy. And then overall, at the bottom, there's a conclusion in respect of flood risk. The important point to note here, my lords, and it's not a point of challenge here, but the fourth bullet point in those conclusions, there is insufficient evidence to enable a conclusion to be reached on the most appropriate return period, and ... The XA are not therefore satisfied that flood risk can be satisfactorily managed. So they concluded that
Sorry, can you just read to the end of that? It's important in the light of the
during construction.
question.
During construction. Well, there's the question of yes.
Yeah, because there's a whole separate bit about surface water during construction, which I've noted.
Precisely, my lord. And then the last bullet point, which is the weighting. It was really a point of fairness to point out that the weighting issue was because of the increased flood risk during construction. That meant a high negative weight in the planning balance.
Yeah.
So the planning balance that's given there, which feeds into the Secretary of State's conclusion, is nothing to do with the pass or fail on the sequential test. That is left open. No conclusion is reached by the XA on the pass or fail of the sequential test.
Yeah.
And is that, don't worry about it, but is that the same for page 765 in the decision letter?
Yes, it incorporates the same weighting.
But it's the weighting when you get to the decision letter, because if they're given it a high negative weighting because of the sequential testing, then that may be a different thing anyway. Go on then, yeah, okay. So that's what they say. They leave open the sequential test. You say because of a misunderstanding.
Yes.
And if they got the understanding right, they would have said you should have done this all along.
Yes.
Yeah.
So the Secretary of State goes back to the parties. The applicant's response to the Secretary of State's questions about the changes to policy is page 237 of the supplementary bundle.
Yeah.
The applicant accepts at 21 that the NPPF is more explicit in referring to any source of flooding, and then notes in the last sentence of paragraph 21, however, within the updated NPPF, the criteria for the assessment and application of the sequential test remains unchanged, with the need to undertake a comparison between the vulnerability of a development and the flood zones. That's not quite right, because it still refers to the application of a sequential approach to all sources of flooding. We've already seen that in paragraph 162. In any event, that's their submission. They note that the planning practice guidance has not been updated, and at 22, it does not provide any criteria for their assessment or their suitability in terms of location, which can be used to determine whether development is appropriate or not. And then over the page...
And do you disagree with that?
Well, it doesn't. It refers to simply risk. It refers to comparative risk without telling you that 1 in 30 means high or 1 in 100 means medium.
So do you agree with paragraph 22? Is it correct or not? It does not provide any criteria for their assessment or suitability in terms of location, similar to that provided for the flood zones, which can be used to determine whether a development is appropriate or not.
Well, I accept it insofar as it doesn't identify zones, but not so far as it suggests that there's no criteria, because the criteria is quite simple. Has it got higher flood risk? If you can put it in an area of lower flood risk, you should. And the PPG is quite straightforward.
But if it's high, medium and low, you say it's not enough to put it into the medium, you'd still have to put it into the low, would you?
You should consider whether there are sites available that would avoid areas of higher flood risk, which would be medium and high. If there's a site which only has medium surface water flood risk, then you'd put it there in preference to high. If there's a low, you should go for that, subject to all other planning considerations.
Right, so the surface floodwater, the criteria are, see if there's any reasonably available site which is lowest, put it there. If not, see if there's a reasonably available site which is medium, put it there. If not, what do you do then? Do you apply the exception test or not?
Yes.
So if you can't put it in the lowest, or if you can't put it in the medium, that's when you apply the exception test.
I can't find a site with lower flood risk, therefore I have to consider the questions.
So mine is specific. You've gone through lowest, there isn't a lowest. You've gone through medium, there isn't a medium. You want to put it in the highest. Is the exception test applicable to putting it in the highest, or is it also applicable to putting it into the medium?
It will be for both. It will be for both. You have to consider then the question, which is it safe? And does it increase flood risk elsewhere?
So you can only put it into a medium or a high if it meets the exception test.
Yes.
And as between medium and high, it's got to be medium first and then high.
Yes.
So there are two criteria. Exception test if not lowest, and a comparative between the two,
Yes.
medium and high.
Put it another way, I cannot find a site where I can locate this development that avoids flood risk, and therefore it must be in an area of flood risk. As a consequence, I have to ask myself another set of questions. Do the benefits of the development outweigh building in an area of flood risk? Is it going to be safe for its lifetime? And is it going to avoid increasing flood risk elsewhere?
So say again, cannot find low flood risk.
Yeah, or lower. So I have to. The point of a sequential approach is you start with areas of lowest flood risk. If you can't locate there, you can move up the tree.
But I've just gone through this with you, and it is my fault, and I do apologise. But I just thought you told me that if you can't get it into the lowest flood risk, the surface water flood risk area, you must apply the exception test.
Well, my lord, it's the sequential test first. So you put it in the lowest area of flood risk, applying a sequential site selection exercise. If you end up in low, you don't need to worry about the exception test.
No.
If you end up in medium or high, you do need to worry about the exception test because you have there identified that there is a flood risk which needs to be addressed.
Right. I suppose where I've got a problem is this, that there seem to be two exercises going on. Whether the exception test is met, and once you're outside low, the exception test has got to be met. Now, as between medium and high, is that something that's caught by the sequential test first? Yes. So you only get to the sequential, you only get to the exception when you've identified the site with the only thing you've got left is a medium or the high, and then you apply the exception to that.
Yes, because you have to. Para 162 of the NPF, the aim of the sequential test is to steer new development to areas with the lowest risk of flooding. The lowest. So you go for the lowest possible. If you can't find the lowest, then you must necessarily look for sites which have a medium level of flood risk. And it's only if there aren't such sites available that you'd go to an area of high flood risk. But if you are going to an area which carries any flood risk, the medium level, then you'd have to consider the questions posed beneath.
So once you're outside the lowest and you've worked out whether it's medium or high, for the medium or high, having worked out which of it is, you've then got to say, and does that meet the exception test? Because if not, you can't have it at all.
Yes.
Okay, that's helpful. Thank you very much.
And then 164 are the two questions posed. MPPF 164 are the questions posed by the exception test, but you don't get there until you've answered the logically prior question. So that's the applicant's response. So effectively, I'm at page 238 of the supplementary bundle. Paragraph 23 explains their position. They say, in the absence of any criteria as to how, and it's how the sequential test should be implemented, the applicants have sought to address the potential risk from surface water flooding by locating the onshore substations and national grid infrastructure in an area of low risk to surface water flooding. That's the first submission, I'll come back to that. And by adopting appropriate mitigation measures within the design. Now, in the first point, sought to address by locating the substation in an area of low risk of surface water flooding. The potentially misleading point here, which in my submission may have misled the Secretary of State, is that whilst they sought to do that, they didn't achieve that. In other words, the flood risk assessment maintained that there was infrastructure in the area of high surface water flooding. In any event, this is the site-specific exercise, the second question under the bullet points in the MPS, moving the infrastructure around within the site. And then it goes on to refer to appropriate mitigation measures. So in my submission, what the applicant's saying there is we haven't done a site selection sequential test for surface water flood risk. They are admitting that the way they have addressed surface water flood risk is to do the site-specific arranging your infrastructure as best you can, and by having mitigation measures. And in my submission, that's no answer at all to have you perform the sequential test for the reasons I've identified.
We need to unpack that. I mean, paragraph 23 could be saying quite simply, we've tried to put it in a low-risk area, and where there's still flood risk concerns, by mitigation, i.e. it's a combination, and you say that's not enough.
Well, it's plainly not what they've done, because they haven't looked to locate the substation site. They haven't looked to locate the substation site in an area of low surface water flood risk. They haven't done that.
No, they have tried to, but they haven't succeeded.
No, well, my lord, no. That's
it isn't right, is it?
In my submission, that can't be right when we look at all the evidence we've been through. what is clear is that in the site selection process, surface water flood risk is not considered at all. The examining authority reached the same conclusion. Considering site selection, surface water flood risk is not on the table for the applicants. What they have done is when they've come to the site, they have looked to arrange their infrastructure to avoid the areas of surface water flood risk, and they have had some success, but they haven't entirely achieved that. But that is the secondary exercise. Try and locate development within your site in an area that avoids the area of flooding. It is the secondary exercise. It is not the site selection logically prior question.
And by that you do mean the whole of the box?
Yes. Yes.
Because we have to be quite careful, don't we, to distinguish between the two. Because some of the, I mean, if the two rectangles on the plan were north east of where they're shown, then none of this would be in an area of surface water risk.
My Lord, yes, or indeed if they were in any of the other 6 locations identified for potential substation locations,
yes,
that wouldn't fall within the surface water flooding zone.
So that is all concerned with arranging the infrastructure within the site.
No, my Lord, there's the that is the secondary question. So that the
Well, I understand on your approach it is, but the difficulty with it, just on a common sense point of view, is that it brings down the whole site because of the precise, well, in fact, it might not be precise, but the indicative indication of where the substation's going to be.
Well, my Lord, that location is more than indicative in the sense that we know the substation is within the box.
All right,
So
but as I say, if
yes,
that was slightly northeast of that, there wouldn't be an issue. So
that's right.
You say your point would still apply as a matter of the process because of the failure to follow what you say is the sequential test.
Well,
so you say that would apply even if none of this was shown on the surface water as clashing with the risk of surface water.
Oh well. The answer then would be easy because you'd say there's no issue of surface water flood risk.
Well, that's the point.
Yes.
But it's because there is an issue with the location of this, on your case, because there is an issue with the location of the substation. You say it's wrong for the development to go ahead on this site.
Yes.
Although that is the only part, the parts shown there are the only parts where there is a surface water risk.
So I think, if I've understood my Lord correctly, and apologies if not, it's that you could still be in Friston, but locate the substation somewhere else within the fields,
Yes.
such that it avoids those lines on the plan.
Yeah.
In principle, that might be for the purposes of flood risk sequential site location. That might be a proper exercise. There are, in fact, all sorts of other reasons why you wouldn't be able to do that. But in principle, that's right for the flood risk question. The point I'm making is that when the applicant comes to saying, where can I put my substations? The applicant, in fact, identifies 7 different potential locations.
Yeah.
But why, I mean, can we go back a stage? You have a development site, which is an enormous thing, marked in red on the box. And the sequential test, stroke approach, is to decide whether that development site should be there or whether it should be anywhere else, isn't it?
Well, my Lord, yes, in basic terms, but
so why does it matter if any bit of the development site, whether it's a substation or not, if any part of the development site is within a high risk category for surface flood water, why does the sequential test say, no, you can't do that, that whole development site that you're applying for must be moved?
No, my Lord, this is where the practicality of the test comes in, and this is about a question of application of the test, where judgments have to be made. And perfectly accept those if they're the planning decision maker. So, for instance, the cable corridor crosses flood zones 2 and 3 because it crosses a watercourse.
Yeah.
And the analysis in the sequential test is, well, however you are going to get from landfall to substation, you are going to have to cross a watercourse. In other words, it's impossible to avoid it because of where you put your substation and your landfall. Sequential test passed for that element of the development. It is not the case that you then say, well, fail entirely for the project, and the project must itself move to a wholly different location. So there's a pragmatic exercise to be carried out.
Can you do the first thing? Can you humour me, please, and put the map on one side of the desk and show me the words in the policy that says I don't need to worry about the whole of the site for which I'm applying for development consent. I only, when I'm applying the sequential test, need to consider whether a particular bit of it, in this case the substations, it could be something else, is in a surface flood risk zone. If we're looking at applying the policy to the test first, where do I get that? What words of the NPS or the MPPF or the PPG do I use to say, aha, it's the rectangular square boxes, not the red boxes, that is the problem?
Well, my lord, the starting with the MPS, it refers to the need to show the sequential test has been applied as part of site selection. And we know that one of the site selection exercises is where can these offshore wind farms connect to the national grid?
No,
and we need
the
to
question
select
is you're getting a development consent for wind farms and onshore cable and substation.
Yes.
That's what the development consent is, isn't
Yes.
it? So if I'm applying, you tell me which document I should go to, the NPS, the MPPF, the PPGs, or any other set of alphabetical things that I read and say, oh, I don't need to worry about all of it. When I'm applying the sequential test, it's only when part of it is within. That's the first thing I'm trying to worry about. And then there's the second question that my lord asked about, well, in reality, if you moved it 6 inches to the right, so to speak, on the map, wouldn't that solve the problem? So where do we start with applying?
In terms of breaking down the development into its
component parts?
Well, the point is, my lord, it's about the existence of risk within the development side.
Yeah, the aim is to steer new development.
Yes.
Well, this is the development, isn't it?
Yes. My lord, I'm not going to be able to show you a passage.
There isn't anything that says
No.
it's part of the development.
Well, my lord, but nor is that my submission. In carrying out this, nobody has disputed that in carrying out the site selection exercise for the substations, you need to apply a sequential test.
Yeah, but you elide the site. That's why I asked you. This started with me asking you by what do you mean by the site? Do you mean the whole of the red rectangular box? And you said yes.
Well, no, my lord.
And that must be right because this is the development site, the red.
Well, the red stretched out into the North Sea.
Well, I understand that.
And to the
I mean, that's one of the
red.
slightly difficult factional things of this. But as I understand, the cable comes in somewhere near Thorpe.
Yes.
And then this is the rest of the development site. And then within that site, there's infrastructure. And we're particularly concerned with the National Grid substation and the substation for this project. And there's another one somewhere on for the other project. But when we're talking about site selection in the policy, they must mean the whole site. Because the policy is all about stopping developers building in floodplains.
Yes.
I mean, that's what this is all about.
Well, my lord, no, I don't accept that proposition because the policy is about flood risk, and whether that is a floodplain or whether that is surface water flood risk is the same.
But that's the thing, because hence the reference to climate change.
Yes.
We all know that developers have been allowed to build far too many properties in areas that have not been built on before because those areas from time to time flood. And whenever you see on the news after bad weather flooding, it's very often new houses. And it's new houses because developers have been allowed to build there when local people have said, well, why are they building there? That's a flood. That's an area that floods after heavy rain. So that's the underlying thing. Hence the reference, completely right, to site. But I think what my lord and I are puzzling over is distinctions between the site and the bits of infrastructure within the site, because the policy is all about the site.
My lord, if I just, so I start with the proposition that there's an offshore wind farm, and you then need to select a place where you're going to connect to the national grid, and effectively the landfall and the cable route are joining the dots in an environmentally acceptable way. So you have an array in a location which is determined, frankly, outside of the planning system, because you get a lease for a block of the North Sea.
Yeah.
And then you have a question of where can I connect to the grid? And in answering that question, the applicant applies a sequential test in respect of flood risk.
To the site. The
To
area of
where-
land for which you're seeking development.
Precisely. So where should I locate this? And this is before the applicant draws any red
And the
lines.
site is the whole of it.
Well, my lord, the red line encompasses areas over which rights may be required, areas of highway where they're going to be
Yeah, of
widened
course.
for the delivery of infrastructure and so on. So it covers a wide variety of matters.
So that's the development site.
Yes, so the sequential test is being applied here in a logical way, but without taking into account surface water flood risk. And the way it is applied is to say, can my onshore site, so the area that contains the national grid substation and the project substation, can that be located in an area of lower flood risk? But the problem is they only ask the question by reference to fluvial flood risk.
Leave aside the fact that I'm just trying to work out how the policy works, because if you're right about how the policy works, that has one consequence. You might think, well, is that what they really meant? Can I ask a different question to try and test this? When you're dealing with a sequential test dealing with river or sea flooding, and you've got zones, is the sequential test looking at whether any part of the development site is within zone 1 or 2 or 3?
Yes.
So the sequential test, when it's dealing with river flooding, then looks at the whole site.
Yes.
So it must be the same if the same test applies on your analysis.
Well, my lord,
To surface one.
I think that's so. You look at whether there is flood risk within the proposed location for the development.
Yes. Yeah. So if there's any flood risk, surface water flood risk from any part of this site, the whole site is out. The whole development site is out.
No. That because you have to say where are you in this. The prior question that's being asked is nothing to do with a red line. It's nothing to do with the red
No,
line.
it's to do with the development site, isn't it?
It's where should I put my substation?
No, it's the development. And the development is
The
thing for which
sequential
it's
test
constructed.
applies to the whole site. I've just written that down. That's just what you said.
Well, my lord, that was in answer to the question. If part of the site for development it has fluvial flood risk, does it need to be considered under the sequential test?
And-
Answer yes.
Yeah, and you say the same is true for surface water.
Yes.
So the fact that there are darker blue lines, areas within the red box, means you say the same thing applies.
Yeah. Yes. My lord, it's
So it
it's
doesn't
where-
matter where the infrastructure goes, as a matter of principle.
My lord, it does. It does.
But why, as a matter of principle, does it matter?
The applicant asks
On
itself,
your, because
what,
you're
yes.
applying a highly prescriptive test.
Yes.
You're saying you've got to do this, and if you don't, it's unlawful.
Well, my lord,
So I'm just testing that by reference to the fact that it's a site, you say, as opposed to within the site.
my lord, we don't have the order plans because I didn't think it would be necessary to show the court. But what the court would see on the order plans is the areas that are identified for the infrastructure development, and then there are other areas which are identified for the acquisition of rights.
I'm sure it's a whole.
The development consent order is because it's this catch-all provision.
I'm sure I'm not making myself clear. I'm just testing your point
Yes.
of principle.
Yes.
Because
So-
your point of principle is that the sequential test applies to site selection, and the site here is this whole site.
Well, the way in practice it was applied is not this whole site, it's not the whole red line. It is the boxes which I showed the court on the alternatives analysis.
But looking at that page, it would matter where you shifted the two black boxes to. There's a chunk in the red line, which is part of the area for which development consent is sought, which is a high surface water risk. So you shouldn't be putting the development.
Quite, my lord, but that area includes, for example, the realignment, the red line covering the realignment of the National Grid overhead lines. There's a substantial realignment of overhead lines. Now, that is not the development which we are concerned with in applying the sequential test. My lord.
Okay. Well, I think the point we probably exhausted the point, but that obviously is a point that arises as on your principle that the sequential test has to be applied in the way that you say, which I understand.
I think I just make two further points, if I may. The first one is that there's a risk of making a nonsense of the test, because if one just takes the whole red line, then of course we include a large chunk of the North Sea, and we would make a nonsense of the test for this type of infrastructure, because either that would be all in or all out. The second point I make is that on the developer's own assessment, which was found, so far as it went, to be sound, it considered not what was in the red line, but where the specific infrastructure was going to be located as part of the development proposals. And if one looked at the approved plans, whilst there is a red line plan that would cover the whole of the red line you see on that drawing, you will see that the development consent to construct substations applies only to a small part of that, which is broadly the area shown in black and blue box.
Yeah. So you were showing us that's the response.
So, and then we get to the decision letter, which I know the court will read. I'll take it as quickly as I can. Page 673 is the start of the consideration of flood risk. Page 674, paragraph 4.4, reflecting the XA's conclusion on the change to the sequential test, the change in approach, described at 4.4. Then in the concluding section on the section on the updates, page 677, 4.23 and following, and at 4.27. the summary of the various positions. The two local authorities take the view that the MPPF has changed, and it means the sequential test does need to be complied with for this development, and if necessary, an exception test. However, they both note that there's no guidance on application.
So where are you reading from?
Sorry, page 678, 4.27,
Yeah.
bullet points 1 and 2. So SCC is Suffolk County Council, and then East Suffolk Council is ESC.
But this is a summary of the responses.
This is a summary of the responses, and then you've got my client's submissions, and then you've got the applicant's submissions summarised. And then the Secretary of State's conclusions are at 4.28, and this is the critical paragraph.
Then can we just look at what the applicant says?
Yes. So all sources considered in design, repeating their substation sites and national grid have been
That's what
located
they've highlighted. There's the other bit before, but we've read it all, yeah. And by design, you think that's where on the development site you locate particular
Yes.
bits of infrastructure.
Yes. They have never thought, can we put it in a different place that doesn't have surface water flood risk? And they don't claim to have done so.
Yeah.
And then 4.28.
And then they go on to say most of it is in an area of low risk. Some of it will not
Some
be
of it
by
isn't.
definition.
Yes, some of it isn't. So the summary have been located. That doesn't actually reflect what was said. It was sought to locate, and in fact not achieved in terms of locating the infrastructure in an area of low risk of surface water flooding. Flood risk assessment makes that clear.
You say that is still misleading because it's not the substation site and national grid infrastructure, because a bit of it is not
A
within.
bit of it. It doesn't. That description doesn't apply to part of the site.
So that's wrong then.
Yes,
It should be and part of the national grid
is
infrastructure.
in low risk.
Yeah.
And then 4.28, the overall conclusion. All sources considered in design, mitigation measures are proposed, then considered the MPPF updates and the consultation responses, noting that the guidance has not been updated, is satisfied that the applicant has, as currently defined, applied the sequential test as part of site selection. And my simple submission is that involves necessarily a misinterpretation of policy, because unless you have considered whether there are sites with a lower surface water flood risk, then you cannot have applied the sequential test as part of site selection.
Wait, hold on. And let's consider.
Unless you've considered sites with a lower risk of surface water flooding, you cannot have applied the sequential test as part of site selection.
Yeah.
So that's why I say there's a misinterpretation. I do emphasise to the court that when the case was pleaded, we pleaded in the alternative that the Secretary of State still hadn't understood that surface water flood risk was caught by the MPPF as it stood, that was a point which was strongly refuted. It was said that this conclusion must be read as saying sequential test for surface water flood risk. But even on that analysis, we say it's quite clear that there's been a misdirection.
Now, this letter is a very strange letter to read. If you go back to 673, there's a bold heading flooding and drainage. There are bits that are underlined, such as the applicant's case, and then they're followed by bits in italics, which sometimes relates to the big heading and sometimes not. And then this section is in a section called Examining the Authority's Response to 677, and it's broken down to various things, and then it's got updates to the National Planning Policy Framework, and then it'll go on in a minute to updates to climate change. But what is the significance of this paragraph? What is this paragraph dealing with, and how does it feed into the planning balance?
So
I know
here,
you say it's a misdirection, but at the
here-
moment, so what? How do
here the Secretary of State wraps up the sequential test point,
Yeah.
4.28, and then it's returned to in the conclusions of the Secretary of State on flood risk,
Yeah.
4.47, page 684. As set out in the previous paragraph, Secretary of State considers, first bullet point, the applicant has, as it is currently drafted,
So you
applied...
said 784 or
684.
or 684?
684, 4.47. First bullet point.
Just let me get there. Yeah. And you just say that's wrong. It wouldn't have been a high negative weight. It would have been completely high negative weight, is it? Or couldn't approve it because they haven't applied the sequential test.
Breach of the sequential test requirement. And what the Secretary of State does with that is a matter of judgment. But it's a critical policy in my submission.
So he's got to appreciate that it's a breach.
He's got
and
to
then decide
appreciate
what
the
to do.
breach. And it's saying, where should we put this onshore infrastructure? And the conclusion is that they haven't shown it should be here in flood risk terms. It may be possible to put it somewhere else. That's the conclusion that should have been reached. Now, where that goes in the planning balance ultimately is a matter of judgment for the Secretary of State. But what I will emphasise here, and when I come on to my next ground, is that this is, at least on the examining authorities report, a narrow decision. There are significant problems with this scheme in terms of its impacts at Friston.
So the problem is the last 10 words or so, paragraph 448, the Secretary shouldn't have been satisfied the policy requirements had been met because the sequential testing bit hadn't been met.
Precisely.
And therefore he would have to go on and decide what to do in the light of that. It's those words that you say are wrong.
Precisely.
Yeah.
My Lords, with no disrespect to the judge, I know the court would have read the judgment, and I think I can, rather than going through that forensically, I can simply say that there are, as my Lord recognised, 2 points. One of them that, in my submission, the judge did not properly interpret the policy because she left it open to a judgment for the decision maker as to whether or not a sequential test was met when it hadn't been applied at all. And that, in essence, is my interpretation point.
Yeah.
This is a logically prior question.
Yeah, I mean, you said it's a point of principle. It wasn't a question of that arose first. It wasn't something that should have been, as it were, a matter of planning judgment to be taken into account in the balance.
Yes.
It's your submission is it's a more prescriptive principle, and the test needs to be applied first.
Apply first,
Yeah,
find a breach, and then you come to the planning balance.
Yeah.
In fact, there's one breach one part of the policy doesn't mean you have to refuse overall, but this is an important policy and
Yeah.
it may make a difference.
Yeah.
And then the second point.
So that's ground 1A. Yeah.
1A, and then at paragraphs 79 to 80, I say that this. In the judgment, I say that this includes a.
This is the Friston point,
the
is
Friston.
Yeah. So before we leave your first point, you say 64 and 65 is simply wrong.
Yes.
It's 64 and 65 that are wrong.
My Lord, yes.
Yeah. Okay, so that's your first ground then.
Yeah.
Sorry.
And it's the last sentence of 65, the acceptance that it doesn't follow that where there is some risk of surface water, it must be positively demonstrated that no sites reasonably available for development with low surface water flow risk. I say that it should be positively demonstrated,
Yeah.
and if not, then you apply a different set of tests.
Okay.
Yeah.
And then one B, as my Lord puts it, is 79 to 80, and I've shown the court the documents. And in my submission, the Secretary of State has picked up the question
Which paragraph? Sorry, just go to which paragraph?
79 to
Making
80.
notes as well. I
in the
can't
judgment.
multitask.
I'm sorry.
Which paragraph? 79?
79, page 139
Yeah.
of the bundle. And it's this reference to low risk of surface water flooding. The substation and infrastructure were located in an area at low risk of surface water flooding. I say that's not actually what the evidence said. The applicant said that they had sought to do so. That was then interpreted by the Secretary of State that they had achieved that aim, and they have not. And the judge makes, with respect, the same mistake the Secretary of State does, which is to take that to mean that there was the question of surface water flood risk had disappeared. It had not.
Well, but she knew that, didn't she? Because you wouldn't have had appropriate mitigating measures to address any remaining surface water flood risk. She may have been inaccurate about the substations, or she may not. But what she knew was that there was a surface water flooding risk, because otherwise why would there be appropriate mitigation?
Well, my Lord, and I say that's the... Yes, quite, and I say that that's the second question, which is can you mitigate, having got to the site? but you shouldn't be in the question of
So
mitigation.
that's your first point.
Logically right.
She's wrong there.
Yes.
This is a different point. You're saying she didn't know what she was doing because she didn't realise that the substation wasn't all located in it, because bits of it are not located in the low risk. But she must have realised that, because there wouldn't be a mitigation. If it wasn't in an area where there was high risk, there'd be nothing to mitigate, would there?
Well, my lord, I'm not sure I go quite that far, because you may need to mitigate surface water issues regardless of flood risk. But certainly the primary point is that that the risk is identified, my first point, and the second point is that you only get to mitigation once you've done your sequential site analysis.
Yeah, but on your separate thing that you misunderstood, if mitigation was intended to address risks still arising from a high risk, stroke medium risk, whilst it may be loose language about the substation, she must have known that there was something that was high risk, medium risk.
Yes.
Unless by mitigation she meant only any remaining low risk mitigation.
My lord, I think that must be right.
Yeah.
My lords, in the skeleton, we refer to two authorities in paragraph 37, which touch on the sequential test in the context of in the context of the first of all the retail sequential test, and then in the context of a local plan policy about a sequential test for waste sites. The judge below didn't find them helpful. I only put them to show that my analysis of a logically prior question about site selection is correct. But I say that that analysis is supported by the paragraphs that I've referred to in those two first instance judgments. The final submission on this point is that my learned friends rely on a recent judgment in the High Court, Wathen Fayed, which I'm not going to go through in detail given the time, but I'd invite the court to consider in full. That's a judgment in the High Court concerning a proposal for a crematorium and related development. And the second of the two issues related to an identified risk of groundwater flooding. And my learned friends rely in particular on paragraph 124 of the judgment of Mr. Mould-King's counsel sitting as a deputy judge, where in considering flood risk for that particular development, the judge accepted that the question of whether a sequential test should be applied was a matter of planning judgment. Mm-hmm. And that's 124 to 125.
Yeah.
Now, I say that is an error. That analysis is an error. I think that there's, in my submission, I won't go into the detail of it, in my submission, this case might be rightly decided, because what we see from the inspector's analysis in that case is that, in any event, taking a pretty narrow view of how to actually look at sequentially preferable sites, you would have ended up here anyway, paragraph 34 of the decision letter. But in terms of the way it is put at 124 to 125, I say that is wrong for the same reasons that the judge is wrong. The question of whether you should apply the sequential test is not.
You say it's absolutely rigid. It must first be site selection, and nothing but site selection. You mustn't be tempted by control by other means.
And that's effectively where Mr. Justice Leven went in the case I referred to in the skeleton Haleback.
In Wathen Fayed, it's fair to say that the principal area of dispute was the Cremation Act 1902. With which, happily, we're not concerned.
My lord, indeed.
I mean, I noticed that the flood risk point takes up about 7 or 8 paragraphs at the end of the
I think
judgment.
if I may leave it as I don't say it's necessarily wrongly decided, but I do take issue with just that part of the reasoning.
I understand.
As I've said.
Yeah.
My lords, I'm sorry, I've been slower than I hoped.
No. Well, we've been asking you
but-
questions. I mean, I think that that principal point that we've been asking you questions about is potentially the most important point in the appeal. Potentially. So forgive us. Don't apologise. It's our fault, but we think it's time probably well spent.
I'm grateful.
Yep, and the two authorities that speaking for myself, I have looked at that you referred to the judge. The judge said she didn't think they were helpful. Are the ones that are identified in her judgment, including Hale.
Yes, it's paragraph 37 of our skeleton.
Yeah.
I think she says there were two authorities referred to which she didn't think were helpful, and I only use them as proposition for it is a prior site selection question.
Yeah.
That's what a sequential test means.
Yeah.
Should mean across the piece, and I think the submission based on these retail question, the retail test, is it's in the same document as in the MPPF. Sequential test, which says you put the town centre first, and if you can't go to the town centre, you go to edge of centre for retail proposals. Same question, site selection.
Yeah.
My lords, can I then turn to the environmental impact assessment ground? The 2017 EIA regulations are at tab 2. I know the court's familiar with the similar regulations for Town and Country Planning Act applications. These regulations follow the same structure and approach, but relate specifically to nationally significant infrastructure projects. And obviously they're both, in both cases, derived from the same EIA directive. The starting point is the law on this, and tab 2 of the authorities bundle, page 13, we have regulation 21, and that sets out the steps that the Secretary of State must take when deciding whether to grant development consent. And the tasks relate to the environmental information. So the first, 21.1a, examine the environmental information, reach a reasoned conclusion on the significant effects of the proposed development on the environment, integrate that conclusion into the decision, and consider whether to impose monitoring measures. The likely significant effects of the development include, and if you go to page 15 of the bundle, we have paragraph 5 of Schedule 4. They include 5e, the accumulation of effects with other existing or approved projects, taking into account any existing environmental problems related to particular environmental importance, etc. So this is what's described as cumulative effects. And then the point is emphasised again in the broader description at the bottom of that page. The description of the likely significant effects on the factors specified in Regulation 5.2 should cover the direct effects and any indirect secondary cumulative ... effects. So cumulative effects. The law on just before I leave the regulations, the environmental information is defined in Regulation 3, and we have that at page 7 of the authorities bundle.
Sorry, I'm sorry to be slow. I'm just trying to catch up. Page 15, the description of the likely significant effect on the factors specified in Regulation 5.2. We haven't got 5.2, have we?
No, but those are the environmental factors that need to be considered. I'll supply that over lunch.
I think just for completeness.
Yes.
Yes, please.
We'll bring a copy after lunch. I don't think anything turns on it, but we'll bring it for completeness. So the environmental information is defined in page 7. So it is the environmental statement, and then it says including any further information, any other information, any representations made by anybody required by these regulations to be invited to make representations, and any representations duly made by any other persons about the environmental effects of the development. So the environmental information is not limited to the environmental statement. and that reflects long-standing case law that you take into account all of the information that you glean from the examination of the application.
It's not even information, it's representation.
Yes. So in basic terms, take that information into account. In Pierce, which is tab 11 of the authorities bundle, Mr. Justice Holgate considered in detail a cumulative effects case, and that concerned two other wind farms with connection points in East Anglia, and effectively the approach of the Secretary of State there was to exclude consideration of the effects of the second wind farm at the substation site where it would also connect. And Mr. Justice Holgate found that to be a breach of the regulations. It's the earlier 2009 regulations, although there isn't a suggestion that there's any material difference, as I understand it. But at page 383, the judge considered whether there was a breach of the regulations in that case. I'm just going to give a few brief references, if I may. Paragraph 105, explaining the obligation to take into account the information from the directive. Paragraph 107, explaining how that has been transposed into, amongst others, Regulation 21 of the 2017 regulations, and explaining the terms of those regulations. And then paragraph 108, which I emphasise in particular the first sentence. Although it is a matter of judgment for the decision maker as to what are the environmental effects of a proposed project and whether they are significant, EIA legislation proceeds on the basis that he's required to evaluate and weigh those effects that he considers to be significant and any related mitigation in the decision on whether to grant development consent. That's a proposition which is central to my submissions. And then there's consideration of cases where you can defer the consideration of other effects. Paragraph 115 notes the judgment of Mr. Justice Sullivan, as it then was in Milne, that EIA legislation envisages that the decision maker on an application for development consent will consider the adequacy of the environmental information, including the ES. What became Regulation 3 to impose an obligation on the decision maker to have regard to a particularly material consideration, namely the environmental information. So it's described as a particularly material consideration. And accordingly, if the decision maker considers that the information about significant environmental effects is too uncertain or is inadequate, he can require more detail or refuse. And then the discussion of the application to this case is at 116 refers to when you need to take into account cumulative effects. 117 addresses the Littlewood case, which is concerned with when you don't know enough about a proposal to be able to establish any information about it for cumulative assessment, and then effectively the judge goes on to explain why this is the case before him was not a Littlewood case.
Pausing there, I understand your submission that you've got to take account of the environmental information, but do you accept that this is a case where it was lawful for the Secretary of State to say, I'm not going to assess the cumulative effects of the Nautilus and the Euroconnect, whatever it's called, because those are insufficiently detailed and just simply too inchoate?
No, it wasn't, and I'll explain why. There's an important point.
So you say that it's wrong for two reasons. One, in any event, information should be taken into account, and two, that he should have done a cumulative impact.
He should have done it because he had.
So he should have done a cumulative impact. They're two separate things.
He should have done a cumulative impact so far as he could about the impact of those connections.
So it's wrong not to take the information into account, and wrong not to try and assess the cumulative impact so far as he could.
Yes. Can I just also, before I get on to the documents, which I can take quite briefly, relatively briefly, can I just emphasise also the recent decision of this court in Ashchurch, which is the last tab of the authorities bundle. Now, Ashchurch is what's sometimes called a salami slicing case, where
Yeah, it's very different there because the project wasn't a bridge in the middle of nowhere.
very different.
It was the housing development which the bridge is supposed to lead to.
Precisely.
This doesn't really help us, does it?
Well, my lord, on substance, no, it's not a close analogy, but it's recent Court of Appeal authority on the purpose with which we're concerned. And can I just emphasise paragraphs 88 through to 89 about the approach that's required to be taken under the EIA regulations. But I accept it's a different category of case.
Sorry, that was paragraph which you wanted us to...
88 to 89. And the point is that it doesn't matter what you have applied for, you've got to think about what is going to come as a consequence of that. And it's a simple position.
A slightly more subtle point, it's not enough to say it's what I applied for. It's in fact what you've applied for is only part of what the project is.
Yes.
You can't avoid assessing the whole project. It's a slightly different point.
Well, my lord, yes, in that context it is. That's a screening case.
Yeah.
No likely significant effects anticipated because it's only a bridge.
Yeah.
And the point is you've got to think about what else is going to come when you build the bridge. In any event, I just show that as recent Court of Appeal authority on the approach. Now, if I can then pick up the supplementary bundle at page 185.
Yeah.
This is the extension appraisal, which is referred to in various places. Just to summarise, the new National Grid substation will become a point of connection for new projects, including the interconnectors. When the interconnectors are developed, they will need to construct their own project infrastructure, which is essentially a converter station. And the converter station will have to be located somewhere in the area of the point of connection. This appraisal is not concerned with the converter stations that will come, the substantial new electricity infrastructure concerned with those projects, but rather with the extension of the National Grid substation that would be required if those projects connect in that location. And in my submission,
I assume my learned friend said they will have a point of connection for the interconnectors. I don't think it's a point of dispute of fact, but at the time of the decision, there was no decision about whether they would in fact connect at that substation. That's clear from the document we're looking at.
I'm not entirely sure I agree with what my learned friend said.
We can't be dealing with matters of fact in the Court of Appeal.
My lord, I don't...
I mean, with great respect, that can be the problem with these planning appeals. You go back to square one as if there'd never been a judgment.
My lord, I don't need that. I can rephrase it so that my learned friend doesn't have to take issue with the way I put it, which is that if those projects are to connect at Friston, it will require the extension of the National Grid substation, and that is a point which National Grid itself told the examination. So they identified, if those projects come forward in this location, we will need to extend our substation.
What we're dealing with is whether or not certain information provided by the applicant
Yes.
is taken into account or not.
Yes.
And that says at 190, the potential. So they don't
Potential.
accept that it was. If they're wrong, it's a different case from what this is.
So they explain there's a lack of detailed information about these various projects, paragraphs 4 and following, 190, 191. The critical paragraphs are at 14 and 15, where they explain what they are actually able to do and what they do. And we note in the skeleton that these paragraphs don't feature in the judgment below. What's said there is the only practical solution, in the opinion of the applicants, is to provide updated information based upon the only element of the NGV projects about which there is any certainty.
You've got to look at 10 to be fair. The reason why they do that is because they say at 10, and you may disagree with it or not, they can't do a cumulative impact assessment. And they say because they can't do the cumulative impact assessment, the only thing they think they can do is the following.
My Lord, yes, entirely. And there's no issue here in this court about whether they should have done a cumulative impact assessment to include the converter stations for these projects. What they provided was an assessment of the extension of the National Grid substation. And with respect to the judge below, her judgment does not include the key reference here, which is where the applicant says what we can do, paragraph 14, is to update the information based on the only element of the NGV projects about which there is any certainty, which is the areas located, locations highlighted as area available for potential future expansion. And that is in a statement of common ground with National Grid Ventures, the applicant. So this is for those projects. And then it goes on to say at 15, this report therefore presents an appraisal of the potential additional effects of the potential future expansion of the National Grid substation necessary to accommodate those proposals. That's what it's doing. And that's as far as it goes. And in terms of scope, what infrastructure is being assessed, there's no issue in this court. It then explains the assessment that's being carried out. I don't need to go into the detail of it. The one point I do emphasise is...
And can I just be clear, is the connector to... an appraisal of the potential additional effects of the potential future expansion. The future expansion will be part of a separate project, if it happens, of the
connectors.
The two connectors. So it's still a different project from this project.
Yes, what is being assessed is that these projects authorise the construction of a National Grid substation. If someone else comes along to make a point of connection there, then they will have to increase the size of that National Grid substation.
So their project will include an extension of the national substation that's part of this project.
The reason I hesitate is that it may not, because that may be done by National Grid under their administrative
But this project is only about the substation for these two wind farms.
Well, my lord,
the extension to accommodate Nautilus and Euroconnect will be a part of a separate project, and that can't be assessed at the moment.
well, no.
So they say.
So no, what they say is they can't assess the impacts of those projects generally, but what they can do is provide an assessment of increasing the size of the National Grid substation to accommodate them. We do know...
Which, although it's not part of this project, for which development consent is currently being applied for, would be part of those other projects.
Would be necessary for those projects.
Yes.
And that's based on a drawing which was agreed with National Grid about how you would expand that substation if required.
They can't assess the other project. They think they might be able to assess a bit of the other project.
Yes. Yes. So they carry out that assessment. They screen out various matters and say we don't need to look at those because they wouldn't produce slightly significant effects. 195, 196, 197. And then they carry out what's entitled at 199 a cumulative appraisal in respect of ecology, ornithology, and at 200 landscape, and at 202 cultural heritage. And they reach their conclusions. The examining authority at page 577 of the core bundle is my first reference. And 7.5.8, under the heading Extension of National Grid Substation Appraisal, XA's view is this assessment demonstrates a significant worsening of potential effects at various viewpoints, and there's consideration of that. 7.5.60, therefore consider the extension would intensify and worsen the effects of the proposed development on both the local landscape and visual receptors. Extension would have an adverse effect on landscape through other effects, and it explains that, including the effect on the sustainable drainage basin, and that's their assessment of that evidence. Mm-hmm. So those paragraphs, and then when we get to the conclusions on landscape and visual impacts, 7.6, over the page 579, bottom of the page, cumulative effects. So they consider cumulative effects between the two East Anglia projects. So remembering again that there are two development consent orders. And then the last bullet point on of 7.6.1, which is on page 580, halfway down, the extension of National Grid Substation Appraisal demonstrates a significant worsening of potential effects for relevant viewpoints and for landscape character. The extension of the substation would intensify and worsen the effects of the proposed development, both local landscape and on visual receptors. And then such an effect would be added to in an unknown way by provision of required surface water drainage. And 7.6.2, last paragraph, well, the whole paragraph is the conclusions on the effect of the proposals. And then last bullet point, in reaching the above conclusions, the XA has not considered the extension of National Grid Substation Appraisal, noting that the applicant acknowledges that the appraisal is environmental information and is not intended to comprise a cumulative impact assessment. So in my submission, that's a nonsense. That if it's environmental information, it's something which they have to consider in their conclusions. And in drawing their conclusions, they expressly keep it out of account rather than take it into account. A similar approach comes up in respect of heritage. And
if it's a different project, which it is, and if they're not satisfied that it's going to go ahead, which we're told they weren't, then it's not relevant to this project, is it?
It is, because it's a cumulative impact.
But not if we don't know whether or not it's going to go ahead.
But we know enough. Well, the fact we don't know it's going to go ahead is not any part of the test on whether you should take into account accumulation. Because if something's proposed, it may or may not go ahead. You still need to consider whether cumulatively it will have an effect that's unacceptable.
Well, on the two things, you showed us Regulation 5, the cumulative.
Yes, paragraph
the
5.
Accumulation of effects. So paragraph 5. Accumulation of effects with other existing and/or approved projects.
Yes.
These are neither existing or approved.
No, but then there's the broader cumulative effects, which includes other things that may or may not have been the subject of a planning application.
Sorry.
See in that regard.
Where's that?
So at the bottom of that paragraph.
Paragraph 5.
Underneath so the description must cover cumulative effects.
Sorry, where are you? Is this paragraph?
Page 15 of the authorities.
Yes.
So paragraph 5 of Schedule 4.
The description of the likely significant effects on the factors specified in Regulation 5.2, which we don't have. Is that right?
Yes, should
cover the direct effects. Right?
The direct effects and any indirect secondary cumulative effects. So the understanding
of the
cumulative
development.
Effects. Yes, but cumulative is the development and others.
I just don't get that. Where does that come from?
Well, my lord, if I go back to
Accumulation of effects with other existing and/or approved projects. That's something you have to take into account, but there aren't other existing or approved projects. So I don't see where paragraph 5 comes in at all.
Well, my lord, the I'm just
The bit you were reading to me is to do with the development.
but it's cumulative with what is there or may come forward in the future. That's
what you
accumulation
say.
is.
Where do I get
Where do you
that
get
from?
that from?
Well, my lord, I don't think there's a dispute on this, I should say. But
Sorry, if it's said as a matter of law that the EIA regulations go beyond existing and approved, then yes, there is a dispute.
Well,
this
that's
is a
my
new
point.
point. That there is policy and guidance about where you might go further than the law requires. That's AN 17, which you have seen reference to in the documents. But as a matter of law, I don't believe it's been pleaded before that there is a legal obligation that goes beyond existing and approved.
I get the policy point,
Yeah.
and there may be an argument that connected with environmental information. I don't know, but just on the accumulation point, I don't read Schedule 4, Paragraph 5 as requiring further information unless it's an existing or approved project. But that is an innocent reading these words. I think I've looked at this before, but it was so long ago I can't remember. So take it that I've not looked at it before. That's just on the face of the words.
And it didn't seem to be the ground of appeal, actually, only for the skeleton. I thought the whole point was they'd said it wasn't a cumulative thing and it wasn't further information, but you said, but it doesn't matter, it's environmental
yes,
information.
yeah,
And because it's environmental information, it must be considered.
Well,
But
my-
not because it's a cumulative impact, which has got to be assessed.
my lord, it's 2 points in the skeleton.
You say one, the environmental information, and then two, you say that Mrs. Justice Lang wrongly allied the potential effects of the Nautilus and Eurolink schemes with the potential effects of the extension of the National Grid substation.
Yes.
But I thought we'd established that the extension isn't to do with this project; it's to do with what will happen if there's another project.
It's a consequence. If you build this substation, it's dealing with the consequence of someone coming along and having to extend that substation for their own point of connection.
Yeah, and if they do that, you'll have to assess that at the stage.
Yes, and what you can't do is leave it until then. That's the
Well, no, you
thrust of the
can
case law.
if you haven't got sufficient information.
Well,
Larkfleet, Pierce, and all those other cases that say
if you lack
if it's
sufficient
rational
information,
to leave it,
if you lack sufficient information, but you have sufficient information here because you know what would be comprised in the extension, so you know enough about what you're dealing with. If you are to extend it, it will have this effect, and that's what the applicant says. They
if
can
another project is
do.
approved, not an existing or approved project, but if another one comes along and it's approved, then you can work out.
Well, my lord, existing and approved, that to me is a new point. If it is suggested by Malone and Friends that cumulative impacts under the EIA regulations and directive only fall to be assessed when there is an existing project, i.e. something already there, or something which is already approved, then that is wrong.
Well, that's what paragraph 5 says.
Well, my lord,
I mean, just on the plain words.
well, my lord, that would turn on its head. It's a large number of the cases, including Pierce, where there was no existing or approved project.
Well, I forget what the words were, but the ones that they have been being developed in parallel.
Yeah, Pierce is as if they had not taken into account when looking at East Anglia 1 North, East Anglia 2.
Well, my lord, it's similar.
I mean,
it's similar to that.
So
But there was no existing or approved project in respect of the.
well, there may be a debate about whether that was existing, but
Well, my lord, if it's said
Anyway,
existing means it's either there or
put it this way: at 2 o'clock, you can, I'm sure, give me a one-word answer or a one-sentence answer to my question, which is that on the face of it, paragraph 5 of Schedule 4 deals with the accumulation of effects in respect of existing or approved projects. Is that right or wrong? And if wrong, which I'm quite prepared to be, you'll tell me why. Okay, 2 o'clock. Thank you very much.
All right.